Good afternoon, everybody, and welcome to the Ellis Law Firm Estate Planning Lunch and Learn here this afternoon. Great to have everybody here. I hope everybody can hear me. It looks like everything is working properly. We're trying to do it. This is one of our new webinar series from our new location here in Ruston, Louisiana. So just to give everybody just a little bit of information about myself, again, my name is Phillip Ellis. I am the owner and the attorney here at the Ellis Law Firm in North Louisiana. We've been doing estate planning practices for several years now, and it's something that we've really developed a passion about, along with a couple other things that we do. But what we found is that a lot of people were coming into estate planning on the back end where somebody had already passed away and trying to clean up any of the messes that were there and trying to make things work better. Well, we're trying to help out with that by putting on these estate planning lunch and learns so people can have their plans already in place. Because one of the biggest and most frustrating things that we saw that clients were dealing with was that, well, mama may have had a certain way of wanting something done. However, that was never memorialized, that was never written down, and therefore it did not occur that way. And so we're a big proponent of trying to get these estate plans done and get them in place. So without further ado, let's do more. So what are we going to be covering in this webinar? Today we're going to be covering what happens if you have no plan. We have lots of people that come into this webinar series that have no plan whatsoever, and so we're going to try to explain what happens if you have no plan, who gets the assets, who is in control of this estate, and what is that process that if you don't have a plan, what does that look like? Because a lot of people that are coming to an estate planning webinar tend to not have a plan in place. So we're also going to talk about what type of plans that we can organize for you and get developed here in the state of Louisiana. Other things that we're going to cover is, what is a will? What can I put in my will? Who's in control of the estate? What is that process after I pass away to see what to transfer those assets? Then we're also going to discuss what is a trust, because that's a big question I get. What is the difference between a trust? What's the difference in a will? And which one do I actually need? We're going to see what we can put into those trusts, who's in control, and what is ultimately the process. And then we're going to cover other things that often go along with estate planning discussions. That's life insurance policies, medical power of attorneys, legal power of attorneys. What is a living will? Because a lot of people want to get that confused with a regular will. That is not the case. So with that, let's talk about first what happens if we don't have a plan. And one of the big fears that I get a lot is, does that mean that the state of Louisiana gets all of my assets if I don't have a plan? Yes and no, but mostly no. It's possible, but there's a lot of exceptions that have to go before we get there. Ultimately, the only way that the state of Louisiana gets your assets is if there's absolutely nobody left within your family to inherit those assets. So that means no children, no parents, no brothers, no sisters, no aunts, no uncles, no cousins, nieces, nephews. I mean, it goes pretty expansive before the state of Louisiana says, okay, that's ours now. So who gets the assets when I pass? Well, we have to turn to what's called the laws of intestate. So the intestate succession is going to control who gets what and how. And that's under Louisiana Article 880. So who gets my assets? Well, it's going to depend on the nature of that particular asset. Is that asset separate property? Is it community property? Because when the laws of intestate control, it's going to determine based on which type of property that's there. So let's talk about separate property first. So this is property that you have either that was purchased prior to a marriage or after a marriage. It's inherited property if it's done correctly. These are properties that only you and not another person, not a spouse, would be owning. So the hierarchy there is very simple. It goes to descendants first. That's children, that's grandchildren. So if there's somebody in that line of succession, that's where we stop. We don't go any further and start looking to say, okay, we have a child of you. You have a child. That's as far as we need to go. We don't look and say, well, we have a child, but we also have parents. We also have siblings. No. If there's a single child and and that's it, that's all that child gets 100% of the succession. If there are 4 children, they divide that into 4. It's very, very simple math. But once we find somebody that fits into one of these hierarchies, we don't look any further for any additional heirs. So what happens if you have no children? Well, then we go up the line. We go and look to see if there's any parents or grandparents that might be able to be able to take in part in the succession at that. But if there's no parents or no grandparents, well, then we go to siblings. This includes, of course, brothers, sisters, and then half-siblings. Again, this is all under the separate property hierarchy. But if we have no children, no grandchildren, no parents, no grandparents, no brothers, sisters, half-siblings, then we go to spouses that are not judicially separated. So if you're married, you will be able to inherit that property. If there's nobody else in this line, then you get to receive that property. And then we go to other relatives. That is, aunts, uncles, nieces, nephews. And again, the first one that's in line or the closest in relation is the one that inherits that. And then if we have nobody in this entire line here, then we go to the state of Louisiana. So what about community property? Well, it's a little bit different. It's a lot similar, but it's a little bit different. We're first going to start off with descendants. However, the surviving spouse will maintain a usufruct. What is usufruct? A usufruct allows that spouse to remain on the property, to use that property as they need to be entitled to any of the fruits of the property. So say this is a rental property and it's got a renter in it and it's generating income. The surviving spouse is able to get all of that. However, the descendants actually have what's called the naked ownership, the raw ownership of the property. But it's very difficult to deal with it because you cannot require the surviving spouse to give up their usufruct. And that usufruct will exist, again, this is under loss of intestacy, until the spouse dies or remarries. In any of those events, then full ownership does transfer over into to the children. So no descendants, well then the spouse inherits. It's that simple. Because at that point, we can only have that community property if they're both married. So if one spouse passes, the surviving spouse inherits, and then after that spouse passes away, well then it's considered separate property at that point, and we go back to our separate property hierarchy. So who is in control of the estate? Well, it's going to depend. Any interested party may open the estate. An administrator is nominated and accepted in the court, and it might be somebody that you don't necessarily want to have in control, such as a creditor, such as a child that's misbehaving. Any of those things could happen if you do not have an estate plan. The rules for who can be an administrator are very, very wide open. And so it's just basically if 18 and you have an interest in the estate, yeah, you can do it. So what is the process of what happens after you pass away without any plan in place? Well, in the most basic terms, we end up filing a petition with the court that includes the petition itself, affidavit of verification, affidavits of death and heirship. If there's a need for it, we have an administrator appointed. We have to have a sworn descriptive list, and then we end up providing a judgment of possession, which actually distributes the assets. So what's the problems with not having a plan? You say, well, Phillip, that's kind of what I'm wanting to do, is exactly what the state of Louisiana has planned for me. Well, in some cases, yeah, that's fine, but I always suggest that any plan is better than no plan. First, again, you have to file a petition to transfer those assets. So this is not something that just because you're the only child that you just get to be able to get all the property without having to do anything further. I dealt with the client several years ago where they were trying to do some estate planning themselves, and they wanted to transfer this property or be able to transfer this property in their will to their only son. The father was also an only child. However, when we got to looking at trying to do the wills, is you have no asset to transfer here because your parent succession was never completed. So as far as legally, the estate still owned that asset, and we were not able to include that in the estate plan directly. We ended up putting in there that it's the interest in that estate plan. And again, I encourage them that we need to open the succession and complete that. But that had not been done and still has not been done at this point. There's also no privacy for your estate. So because you have to file this with the state of Louisiana in the clerk of court, wherever the decedent was domiciled last, it's available for public record. So anybody can go and look at what's included in the sworn descriptive list, who your children are, any of the debts or assets that you may have had. It's all there on public display. There's also no customization. So you cannot do anything that says, oh, well, I want my son to have this and my daughter to have that. No. State of Louisiana does not envision any type of customization or relaxing of the rules just because this is something that you wanted when you don't have a plan. You also don't have control, meaning that you don't get to choose who's going to be the executor or the administrator. You don't get to choose who's going to be the one that's rallying the troops and getting things done correctly. You have zero control over this. And then you also have no asset protection for the estate. Everything that you had is going to be left open and free to for creditors or debtors to come in and seek to attack. It also can lead to infighting amongst family members. So again, this goes back to the whole mama said that we wanted it this way, or mama said this, or daddy said this. And the long and the short of it is, it doesn't matter at that point what mama or daddy wanted if there is no plan or no viable plan in place for those heirs to follow. So that leads us to our next question. What type of plans are there available that we can use to try to prevent some of these problems? Well, we're going to discuss two primary estate planning tools. First being that one that most people are familiar with, and that is a will. We'll go over that here in just a moment. The other one is a trust, and those basically come into revocable trust and an irrevocable trust, two different flavors there, and they have different pros and cons for each. And there's some other tools that that work with these, but these are the ones that we're going to be discussing today. And so we're going to be talking about where a will has more flexibility and flexes its muscles versus where a trust does. So let's talk about a will first. So what is a will? Well, a will is a written document signed by the testator and notarized and witnessed by two witnesses. There are some other formal requirements for a testamentary will. There's also things that are called oligraphic wills that do not necessarily that require the notarization and witnessing. If it is written completely in the hand of the testator and it is signed and dated at the bottom. Those, however, are often more difficult to probate because then people come in and try to say, oh, well, it was changed, this has occurred, that's occurred, and it can, again, lead to some infighting. So what can we put in a will? You can direct any asset to any person or organizations that you desire. There is no requirement in the state of Louisiana regarding that assets have to go to any particular person, with a very, very slim exception, and that is dealing with forced heirship. Forced heirship is if you have any children that are under the age of 24 or have a defined special needs. If that is a case and that's a problem that you have, then you can either bring that and build that into your will specifically, or we can make sure that we have a cutout for them because they are going to be required to it. But the other thing is you can also build in those contingencies. So I've had it before where client says, I want my children to have the assets, not necessarily the grandchildren. So if a child were to predecease a parent in the law of intestacy, the grandchildren get to take place of those parents through what's called representation. But this particular client wanted it just to go to his children. And so whenever if that child were to predecease, rather than it continuing down to any of his children, it actually will be brought back to his own children and redistributed. So if there was 4 children, one passes away, instead of getting a fourth, they all would get a 1/3. You can also control who's going to be in charge of the estate. You can direct that a particular person or organization be an executor or executrix. And so this allows for you to decide, hey, this is the one I think has the most level head and it's going to carry out my desires that I want. You can also create trust. This is great for minor children or grandchildren to make sure that they're not getting something that you want to make sure that anything that we ever give to these children is going to be a blessing and not a curse and a weight upon those children, because if they get a control of an asset, they may not be able to handle that asset and it may get squandered away. You can also disinherit children or any other persons. If you are specific that I don't want this person to inherit anything to do with my estate, then we can build that into your plan. And again, there's no obligation that we follow the intestate hierarchy. So again, we can choose to give things to our children. We can choose to leave the children completely out of it. We can choose to give it to an organization or create a program out of it. The Louisiana gives lots and lots and lots of flexibilities when it comes down to providing this a will. Again, the only real caveat comes in with the forced heirship provisions. So what is the process of using a will? Well, similarly to without having a plan, we must file a petition. It's the same general procedure, but we do have to probate the will and have the executor appointed. That's still fine because we're putting in the person that you want to have in control of your estate. But what's the benefits of having a will? You get to direct those assets. You can control who's in charge. That's the 2 big primary things that are there. Again, whereas in the prior section that we talked about not having a plan and it being having the infighting amongst the children, we based on mama said this, mama said that. Well, we've lined out what mama has said and what mama wants. And we also get to choose the one that's got the most sense to be in charge of the will rather than fighting over who is going to be in charge. So what are the drawbacks with having only a will? Well, again, you have to file that petition in order to transfer those assets. That's a problem because then we get into no privacy for the estate because, again, it's all going to be splayed out in the open. Jackie Kennedy, Jackie O. Right now, you can go to the state of California and actually pull up a copy of her will because the will had to be probated, and it's there for all the world to see. That's just one of the first examples that comes to mind. The other thing is that you have to have them go through the process of filing the petition and the costs associated with that. There's also no asset for the estate, no asset protection for the estate, and you still allow for there to be infighting amongst the heirs or challenges to the wills, whether those challenges be valid or not. You can still have to deal with that. So that brings us to our last estate planning discussion tool that we're going to have today, and that is a trust. So what is a trust? Well, it's essentially a legal document that creates A juridical entity. What is a juridical entity? That's an entity that is living and breathing, much like an LLC for a business or a corporation. And so the good thing about a trust is that you create it before you pass away, and it will actually survive you once you have passed away. And there's some key points to why that's important that we'll get into in just a minute. So what does the trust do? The trust identifies who the beneficiaries are of the trust. These are the people that are going to be benefiting from the trust itself. It also establishes the trustee of the trust, meaning who is going to be the one that's in charge of the trust and make sure that the directives of the trust are actually carried out. It also allows for the succession of trust assets, meaning that if you are the beneficiary of the trust, what happens when that beneficiary dies? Does it go to another set of beneficiaries? Does it continue down the line? Does it go to an organization? All of these things can be taken care of with a trust. And further, a trust, this is where the trust really flexes its muscles. It can create these asset protections. And another point that I don't have on the slide here, you can avoid the succession proceedings altogether if the trust is constructed correctly. So let's talk about the two different types of trust. First being the revocable trust. This is probably what 95% of my clients actually go with. Why? Because the revocable trust is flexible. It allows for changes to the trust during your lifetime. So if you had plans to fund a particular organization and that organization goes defunct and it's no longer there, or if it goes in a different direction that you like, then you have the ability to come into the revocable trust and say, I want to remove that. Or if you have a child that was misbehaving but becomes back into good graces and you want to bring them back into the trust, we can do this. If you ever get tired of dealing with the trust, you can eliminate the trust altogether. And it allows for very easy free movement of assets in and out of the trust. The irrevocable trust is the opposite of irrevocable. Once we create that trust, we cannot provide any changes to the trust. The only way to do that is basically to have the trustee distribute all assets outside of the trust. However, there may be restrictions inside the trust that prevents the trustee from doing that. The irrevocable trust is very, very ironclad. It does not allow for a lot of movements, and there's a reason for it. The irrevocable trust ends up creating the best asset protection as well as long-term planning if there's nothing that needs to be changed. Typically, clients in this situation are either business owners or they're at the end stages of their life, and they already have somebody taking care of everything, so there's no reason, once we get this in place, there is no additional changes that need to be made. So what can I put in a trust? We can put in any asset that you own. That's homes, that's vehicles if you so desire. There's any banking accounts, investment accounts, any of those assets you can place into your trust, and then that trust gets protected by the umbrella of the trust. You can put in there that in order for certain people to get the assets from the trust, that they meet certain requirements. So heirs, just because they are listed in the trust, does not give them a free pass that, hey, I automatically get it because I'm listed in the trust. We can create things like educational goals. You need to finish high school. You need to get a bachelor's degree, an associate's degree. We can create social recommendations. Okay, you need to be married. You need to have a job. You need to be drug-free, things of that nature, before they can be eligible to get any of their trust assets. We can also create guardianships for minor children. This is a big, big thing for those that have minor children still in the home, because if we don't have a guardianship provision that's laid out, then that allows for the court ultimately to decide who is going to take care of your children. And the court's going to basically get it and look at they're going to spend a couple of hours on it and determine who they may think is best to determine the children on paper. The best person on paper may not be the one that you want, or may not have the same values and desires that you have for the children. They may have the familial ties. They may have the financial capability, but maybe they don't have the same values that you do, or that you find important. That's where the guardianship provision is so important. So, who is in control of the trust? This is another big thing. You get to decide. You and your spouse can be initial trustees. Of course, once somebody passes, they can no longer be a trustee. You can build in successor trustees. If you're worried about infightings, you can even have a corporate trustee, meaning a company or a law firm, an attorney, or there are other specialty companies that just simply manage trust for their clients, and they strictly adhere to the trust guidelines. What's important with this, again, you're getting to choose someone that you know and you trust in order to be in control of these assets. So what is the trust process? Well, first, we have to create the trust. Creating the trust is a big ordeal. It's a huge set of documents, and some people get kind of scared by it because it is a lot of pages. But that's actually not the most important thing. If we create the trust and we go through the process of creating this trust, it's great to have that nice set of documents. You feel like you've done something good, but it means nothing unless you do the next part, which is funding the trust. There's a statistic out there that approximately 70% of all trusts that are created are unfunded. Now, what does that mean? That does not mean that, oh, well, I didn't put money into the trust. Funding is not necessarily cash assets that are deposited into the trust, but it is putting assets in the trust, putting your home, retitling the home to the trust, retitling vehicles to the trust, putting bank accounts into the trust if that's what you desire. Because if we create the trust and we put nothing in the trust, then the trust does absolutely nothing. Had this problem extremely recently. It was a trust, not one that we created, but the trust was not properly funded. There was a catch-all provision in this trust stating that all banking accounts and stock and brokerage accounts were to be included into the trust. The bank that these accounts were at, though, we have fought with them for several months now, trying to get the trustee access to this account since the initial trustee has passed away. And again, because that trust was not properly funded with that asset being inside of the trust, it created a massive delay in being able to act as a trustee in that regards to that bank account. And ultimately, because it's still an ongoing thing, I think we've got to resolve, but it may ultimately require that a succession be open in another state where this trustee or the grantor of the trust resided in when they passed away. And again, it's a huge mess. So it just really emphasizes the importance of funding a trust. So, what are the benefits of having a trust? Much like a will, you get to direct those assets how you want. You get to control those assets. It also builds in asset protections. How does it do that? Because that's one of the biggest things, again, where the trust is able to flex its muscles. So let me kind of go into that for just a moment, especially with Medicare or Medicaid when you're looking at that. Medicare and Medicaid look at two primary things in determining benefits and whether or not you may have to sell everything that you own to have their services. The government, in its infinite generosity, allows you to have your personal home, a personal vehicle, and around $2,000 in the bank. A lot of people may have more than that. Or if they get any more than that, they don't necessarily want it to go to Uncle Sam. So with the asset protection mechanisms, we're able to divest clients of the ownership of that property. That's one of the primary things that Medicare and Medicaid are looking at. Who owns a particular asset, and can they be forced to deprive themselves of that asset through selling of an asset or cashing out a life insurance policy, things of that nature. The other thing that Medicare looks at is control of the asset. And that's where sometimes with the end of life planning that we do, we will recommend that somebody be actually, that the grantor not be the trustee, because we want to remove them and have an additional layer of separation from them and their assets, to where the trust is still there for their benefit, but it's not, they don't have the control, so they cannot be required to surrender any of those assets. The other thing that a trust does, it prevents challenges. Why? Because we will put in specific language that doesn't allow them to challenge, or if they do so, they may not be able to participate in the trust any longer. But it's also because we're not filing this in court, it makes it to where it's much more difficult to have those challenges. And your estate remains private. Again, kind of what I just dove into. There's no succession that we have to file in order to transfer these assets. Why is that? Well, again, if you remember when we started talking about the trust, we're creating a juridical entity. It's going to live while you're alive, and after you pass away, it's going to continue living, which means that it can pass these assets on even after you're no longer here. And so there's no, because it is its own entity, it can pass those assets without the requirement of having court approval or having them come step in. So what else should I consider with my estate plan? Well, one thing that I always tell anybody to consider is your life insurance policies. If you have them in place, or if you don't have them in place and you want them, getting that in place. In many cases, you just need to update the beneficiary. Life insurance companies do a very good job of distributing assets when the beneficiaries are done correctly. And so the main thing is making sure that it goes that way. A key example came from a neighboring parish here several years ago, where the ex-wife was still listed as the beneficiary on a life insurance policy when the ex-husband passed away. New wife was went to the mat, basically trying to say she is not entitled to it because I'm his wife, not her. And the court ultimately found this: no, is a beneficiary is a specific person, and he listed a specific person. Therefore, she was entitled. The ex-wife was entitled to those life insurance policies. So it's very important to make sure those are updated. And while you're considering your estate planning, that's a good time as any to make sure that those are correct. But another question I get is, does the assets from a life insurance policy need to be directed into a will or a trust? No, not necessarily. Again, life insurance policies do a good job. If there is some type of income testing for benefits, again, Medicare and Medicaid, and we need to not have that person get into possession of those assets because they're going to lose their benefits, then we might need to do some special needs trust planning. But that's a little outside of what we're doing here. It comes in with the estate planning if we need to, but that's again where other things that we consider in assets is whether or not your potential heirs have any of those requirements that we need to try to avoid them receiving a lump sum of cash through a life insurance policy or a lump of assets that may disqualify them from any of their benefits. So what else do we consider? Well, we like to consider the legal power of attorney and healthcare power of attorney. And what's a legal power of attorney? It sounds like what it sounds like. It makes, this person allows for you to make legal and financial decisions on your behalf. And the way that we design these is that they take effect in the event that you become incapacitated. Or we also have we always provide a form with it that in the event that you can see that you're heading that way and you want them to go ahead, it can take effect upon the signing of that document. One of the big things about setting this out with your estate plan is that you get to choose your power of attorney. And so we'll get into that in just a little bit more here in just a second. So what about healthcare power of attorney? Well, it's like what it says. It makes healthcare decisions on your behalf. And this also takes effect when you become incapacitated and you get to choose your own power of attorney. So again, I teased the power of attorney bit just a little bit. I wanted to get to hear this point here. Why is it important that you get to choose your power of attorney? Well, one, again, is having control and knowing who you know to have control over your life. And this power of attorney between the legal and the healthcare power of attorney does not necessarily have to be the same person. We found years ago that a lot of times that we have clients that are better with business and legal decisions, and one that is more healthcare oriented and can make better healthcare decisions. And so that's why we have separated these two out to where you can have a different legal power of attorney and a different healthcare power of attorney. So what else do we consider? Well, something that's called a living will or advance directive. This is not the will that we discussed earlier. The living will has to deal with whether or not you want life-sustaining support if you're placed on the ventilator or not. So it allows for you to make that decision, as well as decisions about organ donations. This is again a very important thing, and most of the time if you're going into a hospital, if you're being admitted, this is something that is often brought up by the healthcare managers that are there to determine that. But I think it's always better when you're not in the fight or flight mechanism that you're going through. You're not in the heat of the moment of dealing with the medical crisis to make this decision when your head is clear. So, what is right for me? What is the right plan for me and my family going forward? And this is somewhat where I get to speak a little bit against interest here. Does everyone need a plan? Not necessarily, but I do believe that everyone needs a plan. There are some people that are served just fine with with the intestate succession, but I always believe, even if we're restating who is going to be getting what as in line with the regular succession, everyone needs some type of plan. But not everyone needs a trust. So that's not what I'm here to do. I'm not here to ever sell every client that I ever have into a trust. And that's, to be fair, I do far more wills than we do trust because that's what they need. So what are some general considerations for I need a trust? If you own a home or a business, those are often things that will trigger, hey, I might need a trust. If you have concerns about Medicare or Medicaid, if you have a blended family, because that's where things kind of can get even more sticky. If you have over 100,000 assets, and that's including your home and any retirements, and if you have dependents where you receive assets directly will cause them to lose their benefits. That's where I was discussing earlier, like with the life insurance policies, if you just give them some of their assets, it may bump them out of the ability to continue to receive those benefits. So, what is the best way to determine what plan is best for me? Meet with us. We'll do a comprehensive review to see what fits best for you. And again, our goal is always to assist our clients, even if that means that we're doing something that is that either we're not creating a plan for whatever reason, or if we're doing a lesser plan or doing a different plan. We're not here to benefit what benefits us best. We are really here to try to help our clients. So what does estate planning cost? Well, we offer what's something that's called a life and legacy planning session, where we sit down and we go in depth and determine what plan is right for you. Now, that typically is a $750 fee. Stay with us, though. There's an asterisk there for a reason. But again, we go through what assets you have, what liabilities you have, what is it that you're wanting to do in order to, what is your ultimate plan? And we go, again, a lot of depth into this, trying to figure out what is right for you. So what does estate planning cost? Our ranges are anywhere between $3,000 and $8,000 on average. Some are a little less, some are a little more. But again, this is the average. The biggest thing is that we're not going to tell you which plan that you have to do. You are in charge of this. You will be able to choose which plan you want and any extra features that you would like to have with it. And the other thing is that you have with us, you're going to have assurances that your plan will work. We have been doing these. Our plans have not failed when they are executed properly. We've had some clients that did not necessarily execute them the way that we told them to, and we've had to clean those up. But that's fine. We're always there to also help clean it up. But again, that's a lot of commitment there. There's a lot of things that are going on with that, and we don't want to scare you off. We want people to be able to get their estate plans in order. So here's what we're going to do. We're going to give you a gift. This is a golden ticket, and we'll waive any of the fee regarding that legacy planning session. And so that $750 value we'll get for free if you continue on with an estate plan. And you basically got to do two things. You don't even have to continue on with the estate plan with us. You have to do two things. One, schedule that life and legacy planning session by either calling us at the number below or emailing us at plan@ellislawla.com. And we'll provide you with some homework that you need to complete at least 3 days prior to your planning session. So you do those two things, and we will give you that $750 session for free. Now, of course, the hope is always that you continue on and get a plan in line for you and your family, but there is no obligation there. So this is the time that I like to open up any questions that anybody may have. So if you have any questions, feel free to drop them in the chat there. I'll go over some of the other questions that I do typically get through these things. One being, what does it mean by the funding of the trust, and what can I do with a trust outside of the that I can't do right now? And long and short of it is, a properly designed trust should always benefit you, and so therefore you cannot you just basically live your life. Rather than it being your name at the top of the check, it'll be the name of the trust. But so as far as any transfers of assets, homestead exemptions, all of that still remains the same for you in your life. But the actual owner of the asset is what changes, but it's still there to benefit you. Another question I get is, will I look at a will that somebody else has created and determine if it is efficient? Yes, we do free will reviews, and there have been times that we'll look at it and say, yeah, that will is perfectly fine. You tell us what you're wanting to do, or actually what we'll do, we look at the will and we'll say, this is what this will does. Is that what you're wanting to do? And that may be all that has to be done. Again, our goal is to make sure that estate plans are done and are placed correctly to achieve the goals that you're seeking. Unfortunately, though, we do see a lot of these plans, either they're done online or used to be able to buy them. I'm not sure if you still can or not. You used to be able to buy them from stores like Office Depot, Walmart. You could buy a big pack of succession planning documents, and what we found is that a lot of times those documents either were deficient, they didn't have what certain requirements that they needed, or because they weren't sure about what they were doing in completing their estate plan, it didn't accomplish their goals. So it's kind of the two different ways that can go. Either it can be the wills can be fine and doing exactly what they need to do, or there may need to be some changes. Uh, and so that's kind of where we're going to leave it off here today. We've gone about 45 minutes. I want to thank everybody for joining us. If you have any questions, again, feel free to give us a call, 318-513-3175. Shoot us an email at plan@ellislawla.com. Or if you want to stop by, we're at 2100 Floyd Park Drive here in Ruston. That's the Kentucky Ridge office complex. We've transitioned up here in 2025 and from Farmerville. Really enjoying it here, and our clients have really enjoyed being able to come and meet with us here. For joining us, and we look forward to anybody on the next one. Take care.